and I will pass it over to them. So thank you.
Thank you, Maddie, and hello, good afternoon to everyone, or good morning, depending on where you're joining us from. Um, Thank you for joining us this afternoon. We'll spend the next hour just talking about the evolving immigration landscape and its impact on work authorization. Um, our focus is on understanding any changes that might impact employment eligibility policies. But before we even get to the changes, we want to make sure that, folks have an understanding of the different options of going through employment authorization, the non-immigrant visas that are available, the immigrant visa options that are available. And then once we have an understanding of that, then we'll deep dive in and discuss a little bit about the current changes that are taking place with the current administration. So, just as a brief introduction, my name is Sella Stockley. I'm a senior associate with Fragomen. I work at the Fragomen Boston office. Fragomen has offices all around the United States and internationally. So my colleague and I work in the Boston office. I've been practicing immigration for quite some time now, specifically business immigration. So this is my wheelhouse. Love this topic and very excited to be here with you today. I'll let my colleague Pamela introduce herself too.
Thank you, Stella. My name is Pamela Fuentes. I'm also a senior associate. I work with Stella in the Fragomen Boston office. I have been practicing in immigration for over 10 years at this point. For the last several years at Fragomen, solely business immigration, but I have worked in the spectrum of immigration law, including removal defense and family-based as well.
Thank you, Pamela. So on the agenda for today, we'll start off by discussing the various employment-based non-immigrant visa categories. And then we'll talk about the employment-based immigrant visa categories that are available. Then we'll touch a little bit on employer sponsorship and compliance. So if you are an employer, what are the things that you should take note of just to ensure that you're complying with immigration regulations? And then after that, we'll discuss the updates under the current administration. So before we begin, we figured it would be, nice to just show and briefly discuss how do companies use immigration. Sometimes when we say we're business immigration attorneys, people look at us like we have two heads. Like, what does business immigration mean? So the goal is, we're helping employers and also helping employees to facilitate work authorization in the United States for themselves and for their families. So how companies use immigration, they use immigration to transfer their employees between different countries just to ensure their skills are being assigned to different places, depending on their business needs. Companies use immigration to acquire new talent through new hires who are not nationals of the hiring country. And then companies also use immigration to send business visitors for short-term business needs. So if there's a meeting in country A or country B, they'll need immigration to facilitate the correct visa for that employee to use. And also to access special programs as needed. So various reasons why companies will use immigration, but as you can see on this chart, the blue, the biggest portion is work authorization. So companies are focused on trying to get their employees to have the adequate work authorization documents to allow them to work in the United States. So we'll start off just discussing employment-based non-immigrant visa categories, just to ensure everyone has an understanding of what the different non-immigrant visa categories are and how they can be used. First things first, what is a non-immigrant? I'm sure we all know this, but a non-immigrant is a foreign national who's coming to the US temporarily, whether it's just to visit or to work, but they're coming here temporarily. The main thing to remember with the non-immigrant status is that your your intent, you have non-immigrant intent. You are retaining your residence abroad and you're intending to eventually return to your home country. Some visa categories in the non-immigrant visas do have dual intent. So some of them do permit individuals to enter as a non-immigrant, and then eventually they could change their minds and pursue a green card, or pursue permanent residence. So it's only a few visas that permit this dual intent. One is the H-1B visa, and another one is the L-1 visa. So those are a couple that, um, have dual intent. You can come in as a non-immigrant, and if you change your mind and decide you'd like to apply for a green card down the line, that is okay. Now, for non-immigrant visa classifications, there are very many. They call it the alphabet soup of non-immigrant visa classifications from A all the way to V. So we're not going to spend too much time. We'll just focus on the ones that are commonly used by companies in the US. So some common business visas are B1, which is for business visitors who are coming into the US temporarily. And then another one is for professionals. So you have H1B, TN, E3, H1B1. These are very commonly used visas that are used for employees in the United States. Um, the H1B, most of you have probably heard about it. It's lottery based. There are ways where you can apply for it without going through the lottery, but most people have to go through a lottery to apply for the H1B visa, and you require an employer to sponsor you for that. The TN, that's reserved for Canadians and Mexicans. So Canadian and Mexican nationals can apply for the TN visa that will allow them to work temporarily in the US. And then you have the H1B1 and the E3, which are usually reserved for treaty countries, for employees who are from specific countries to allow them to work in the US. The L1 visa is for intra-company transferees. So if you're a company that has an office in Spain or England, and you also have an office in the US, and you want an employee to move from that company abroad to work in the US, then you would use an L1 visa to allow them to work in the US. And then you have other visas like the O1 visa, which is for nationals of extraordinary ability. These are people who are considered to be at the top of their field in the sciences or the arts. They would apply for the O1 visa. And then students on practical training. Most of us, I'm sure, have heard of the F1 visa for students, and the J1 visa, which can also be used for students. And as you can see below there, the J1 is also used for trainees, the J1 and H3 visa. So people coming temporarily here to train for a specific duration of time. And then you have the treaty traders and investors, which is the E1 and E2 visas. So people who are from specific countries that are treaty countries with the US, they can apply for the E1 and E2 visas. So we figured we should spend some time just discussing the F1 student visa because a lot of foreign nationals do come to the US using an F1 student visa, and then eventually will maybe try and change their status after they graduate with their F1 student visa. So some employment options. You come in as a student. What can you do to work? One option is the OPT, which is the optional practical training. The OPT allows you to work in the US while you are a student. The OPT is a total of 12 months. So you can work part-time during the school year, or you can work full-time during school vacation periods, or after graduation. So all that time tacks on, but you have, a total of 12 months that you can use during each degree program that you are doing. Now, one caveat is if you are a student who is in a STEM field, then you get a 24-month OPT extension. So that gives you extra time to be able to work in the US. One thing to note is that for you to be able to work, you need to apply for an employment authorization document, which is also known as an EAD card. So that EAD card allows you to basically work for any employer. It's not tied to a specific employer, which is great. So it's open market. Use the EAD card to work for that employer. If you're someone who is in a STEM field and you've applied for this 24-month OPT extension, the employer has to be participating in the E-Verify program. So it can't just be any employer. The employer needs to be participating in the E-Verify program. So you have the OPT options for working, and then you also have CPT, which is curricular practical training. It's part of an educational program. This one usually has a little more involvement by the sponsoring employer because they need to, you need a letter from the school, and then the job duties have to be, there's a little more involvement there, but it needs to be a part of your educational program and related to the what you're studying in school. And then you also need your I-20 to be endorsed. And now I'll pass it on to Pamela, who can just talk about transitioning from OPT to H-1B.
Thank you, Sala. Okay, so as Stella had mentioned, it is a relatively common journey there for an individual to arrive first in the US through the F1 status and then potentially decide, they would like to remain for whatever reason. So with respect to OPT, Stella had already mentioned it does grant 12 months of work authorization. There is this 24-month extension that's potentially available for certain STEM areas. And of course, if someone qualifies for that, that is great because it does require, provide this rather extended amount of work authorization that is not employer specific. It allows exploration of the job market and the career trajectory. Now, the H-1B lottery is a common, essentially, step to go from F1 to, say, end up in the H-1B lottery if there's an employer who is willing to take the foreign national along that journey. The H-1B lottery was actually just completed. H-1B status has been in the news a lot. It's definitely been a focus here for the current administration. It is competitive. That's probably a little bit of an understatement. There are only 85,000 H-1B visas available per fiscal year. And ever since, for as long as I can remember, the demand for the H-1B category has far exceeded that figure. So it is something where to call it a lottery is pretty accurate in that sense. Now, one of the great things about being selected in the H-1B lottery when someone is in F1 status is if they are currently working under the OPT framework, the filing of the H-1B petition by the employer allows for this cap gap extension, allowing the individual to continue to work pursuant to that OPT, even if it is, say, set to expire in relatively a short amount of time, or let's say just before the H-1B status were to take effect. It allows them to continue to work. So it is a really great mechanism. It is, of course, absolutely critical that that H-1B petition be filed in time and accepted by USCIS for processing. So this means that by June 30th, that petition has to be in USCIS's hands and, of course, not rejected. So accepted and moving along. Now, the reality is that, again, not everyone gets selected in the H-1B lottery. Again, it is quite competitive. So what does that mean from an employee perspective, from an employer perspective? It means planning now has to be looked at. And this type of backup planning tends to really look a few different ways. One can be, for example, some companies have flexibility with respect to international transfers that can therefore permit the employment to continue with this overall company, just potentially in a different location. There's also, of course, the question of whether or not there are other status or visa category options that would be applicable. Stella went through the alphabet soup and many of the common categories. So it could be something to look at, say, an O1, which is a very high threshold, but it could be at least worth looking at to see if it would be viable. Or say, for example, an employee is married and their spouse has their own independent immigration status. potentially that employee could move to the dependent or the derivative immigration status for their through their spouse. And depending on what that status is, there may or may not also be work authorization afforded through that status. So an important takeaway here is this fourth bullet point in terms of, planning, making sure communication is open and detailed to ensure that all of the information regarding a particular employee's immigration profile has been considered, so that if there does need to be planning, it is able to be a comprehensive and robust planning to allow for as little disruption as can be secured, and also, of course, as always, retaining valuable international talent. We can move to the next slide. Thank you. So a question that is very reasonable to come up when someone is going ahead and setting up their own immigration status through an employer such as H-1B or something else is, well, what about my family members? Can any of them work? If yes, what does that look like? So the answer to that question is yes. Sometimes it is absolutely possible for a spouse to work. As you can see from this chart, for example, L2S. So L2 is the derivative of the L1 status. E3D is a derivative of the E3 status. These spouses are going to have work authorization incident to status, meaning there doesn't have to be a separate application procedure to secure that work authorization. Once they are in that status, whether it be by entering the U.S. initially and holding that status, or say changing to that status, as of that effective date, they have work authorization. As noted here on the slide, that work authorization, its validity or term, it lasts for the amount of, or the period for that status. So if L2S status, say, is set to expire July 30th of 2027, that is how long the work authorization period is in place. There is no automatic extension as noted here. So trying to file these renewal applications of statuses as early as possible is quite helpful on that front to avoid or minimize as much as possible any gap in work authorization. H4 is the dependent status for H-1B. So this is a situation where some H-4 spouses will be able to secure work authorization. It is not incident to status. They do have to file the application for it. It is for the validity period of the H-4 status. One very important detail is that in order for an H-4 spouse to be eligible for work authorization, the H-1B, so their H-1B spouse holder, must have an I-140 approval through a company or say self-sponsored in some categories. We're going to talk about I-140s a little later, but that is a very important detail, which is why not every H-4 spouse is going to have access to work authorization. And then J2 is for the J1 principal, F2 is for the F1 principal. Again, F2 is, unfortunately, it is not available, which can, of course, be challenging. J2 fortunately does have that availability, again, separate application, and even for children, which is really quite flexible, but that is unique to the J2 category. So another equally important consideration, particularly under this current administration, we would say, is maintaining non-immigrant status. So this is something where as much control as an employee or an employer can have in this realm to make sure they're doing that. Tracking is going to be very important in terms of making sure expiration dates are properly tracked and therefore accounted for. But a few quick points to keep in mind are, one, and this is, I would say, a relatively common misconception, is that the visa stamp that is in someone's passport that's issued by the U.S. consulate abroad when they apply for it, that visa stamp is not what dictates the time that an individual is given to remain lawfully in the United States. The visa stamp is exclusively a travel document. So when someone leaves the United States, it is important, critical, essential to have that visa stamp be valid, unexpired, in order to re-enter the United States. But again, it is for travel. So maintaining non-immigrant status, what you're looking at is the I-94. That I-94 may be issued in terms of the one that's most recent, and therefore the one that is dictating the validity period of non-immigrant status. That could be the one issued by CBP during the most recent entry, or if there has been a more recent application in the United States by, say, an employer to secure an extension of status or a change of status, that the I-94 will be attached to that approval notice. But that is such an important document. It's really important that when someone leaves the United States and they come back and re-enter, to download that electronic I-94 as soon as possible from the CBP website, review it, make sure everything looks in order, nothing has been shortened erroneously, as does tend to happen at times with USCIS. So in that vein, consequences of overstaying the I-94 expiration date are identified here. So overstays can be incredibly complicating for an individual's immigration history. It can result, well, it means someone is not currently maintaining non-immigrant status. Of course, that's a significant concern. They may still be eligible to go ahead and essentially re-enter in the status, but they would have to leave. They would have to leave the United States, and hand in hand with that, depending on how much time there has been in the United States in this overstay kind of phase, it could result in bars to return to the United States. As noted here, more than 180 days of overstay under the law, it's a 3-year bar. Over a year, it may be 1 year and 2 days, it may be 20 years, it doesn't matter. Over a year, it's a 10-year bar. So these are significant time periods that you would not want to be subject to. And so if there is an overstay, of course, very critical to go ahead and touch base and speak with an immigration attorney to receive the proper guidance. And finally, it is very important that whenever an individual, a foreign national, moves, that they update their address with USCIS. The law says within 10 days. So it does have to be submitted. It can be submitted online, fortunately, these days. Just a quick practical point there is that if you are submitting that AR11 or that change of address request online, to go ahead and make sure that you retain proof of the confirmation of its submission. Save it, print it out, whatever you need to do in case it is ever needed in the future. And it'll back to Sella at this point.
Sorry, I was on mute. Thank you, Pamela. So now we have a good grasp of the different non-immigrant visa categories. So we'll spend the next few minutes just going over the immigrant visa categories. And the immigrant visa categories, this is basically the path to a green card, the path to permanent residence. So what does the process look like? The employment-based green card process has 3 major steps. So the first step is the permanent labor certification. The perm labor process, when we say labor certification, what does that mean? It basically means that the U.S. employer needs to test the job market and show that there are no qualified U.S. workers who are available for that offered job and position. And how do they test the job market? The Department of Labor has several steps that an employer needs to follow to do this perm labor certification. So it's posting ads in newspapers, on the employer's website. There's several steps that they need to follow. Post the ads for a specific period of time, and then if people apply and they don't meet the minimum requirements for the role, then you can say, okay, we tested the job market, no qualified U.S. workers were available, so now we can move on to the next step of sponsoring this foreign national for this green card. So the next step would be for the employer to file the perm application with the Department of Labor. So they file the perm application. Hopefully it's approved. If it's approved, they can then file the I-140, which is the second step. The I-140 is an immigrant petition. It's filed with U.S. Citizenship and Immigration Services, also known as USCIS. The employers file this I-140 petition basically to confirm that this foreign worker is eligible for the selected green card category. And we'll go over in a few minutes just what are the different green card categories that an employer will be sponsoring someone under. So if the I-140 is hopefully approved, then you move on to the third step, which is adjustment of status or consular processing. This is the last step to get you that actual green card in hand. Um, the final stage is if you're present in the United States, you can file the adjustment of status. So you're applying to adjust your status from a non-immigrant visa to an immigrant visa. So you're adjusting status here in the United States. If for one reason or another you don't qualify to adjust here in the United States and you need to apply from a consulate abroad, then you would go through consular processing. Or also, if the individual is not present in the United States, they're currently abroad, then they would just go through this process through the consulate abroad. Later in the presentation, we'll briefly touch on some changes to do with adjustment of status. There's something that just came out about 2 weeks ago. Some of you might have seen it on the news about adjustment of status. So the current administration is trying to restrict the adjustment of status process and trying to make it so that most people consular process rather than adjusting status here in the US. But we'll talk about that later in the presentation. So that's the final step. So hopefully the adjustment of status or consular processing goes well. Then you get the green card approval, and eventually you get a plastic green card in the mail, and that is your immigrant visa / green card. And you would then be considered a US permanent resident. Now, you have to ensure that throughout this process, you maintain your valid non-immigrant visa status, especially now. The current administration really wants to see that even individuals who are going through this green card process are maintaining their non-immigrant status. So if you're going through this process, you just want to ensure that you're starting the process early enough, initiating the green card process early enough so that you maintain your valid non-immigrant status throughout, if possible, and reduce any risks from any delays or backlogs that might take place during this process. So what are the categories? These are, on this slide, you'll see the three different employment-based categories. These are the primary ones. There are other ones, but these are the primary ones that we will focus on today, which is the EB1, EB2, and EB3. EB1 is for priority workers. EB2 is for advanced degree professionals and aliens of exceptional ability. I don't like the term aliens, so we will change that in the next slides, but this is just how it's described in the law. And then EB3 is professional, skilled, and unskilled workers. So we'll discuss this a little more. So EB1, priority workers. The EB1 there's three subcategories. It's a high criteria. It's usually difficult to get these cases approved, but if you do qualify, this is a great category to apply under because there's no labor certification required. An employer does not have to go through those steps of posting ads and trying to see if there's a qualified US applicant. If you just file the application and if it's approved, then that's it. So it really does decrease the timeline and the processing time for the case if you can qualify for the EB1 because you don't have to go through that step of labor certification. So what are the three subcategories? You have the EB1A, which is for individuals of extraordinary ability. These are people who are at the top of their field, and those fields are in the sciences, arts, education, business, or athletics. The EB1A, the good thing is it could either be sponsored by your employer or it could be a self-petition. So you could just sponsor yourself and file this on your own if you do qualify. The EB1B is another subcategory, and this is for outstanding professors and researchers. So this one does require you to have an employer sponsoring the petition. It's usually reserved for, as the name implies, professors and researchers. So you need to show that you have work that is internationally recognized in your field. And the USCIS does a good job of just basically laying out the criteria on their website of what you would need to submit to basically show that you do qualify for the EB1B. The EB1C is reserved for multinational managers and executives. So for this, again, you have to be sponsored by an employer. It cannot be self-sponsored. This is for companies that are doing business in more than, or at least two countries. So if you're a US company and you have an office abroad, then you could potentially sponsor one of your employees for the EB1C visa. Um, you would just need to show that that employee was employed both abroad in a managerial or executive capacity, and that they are also employed here in the US in a managerial or executive capacity. So both here and abroad, they worked as a manager. Um, and if they did, then they may qualify for this EB1C visa. The EB2 is the next criteria, and this is reserved for individuals who have an advanced degree and are persons of exceptional ability. So what does advanced degree professionals mean? That means that you are someone who has a master's degree and above, or you have a bachelor's degree and 5 years of progressive professional experience. So if you can show that you are someone who has this, you're an advanced degree professional, then you could go through this process. This does require a labor certification to qualify for the EB2, so you have to go through that perm process. However, there is an exception, which you'll see at the bottom of this slide, which is a waiver of a labor certification is possible if you can show that the work that you're performing is in the U.S. national interest. As you can probably imagine, showing this is not easy because you do have to show that the work that you're performing is the work that the U.S. would consider to be in the national interest. Right now, there's high scrutiny with the national interest waivers. But if you do qualify for a national interest waiver, it's definitely something worth looking into because it's in the EB2 category and you don't have to go through the labor certification process. So much faster timeline if you do qualify for the EB2 national interest waiver. EB3, this is reserved for professional, skilled workers, and other workers. Um, It's so professionals are positions that require a bachelor's degree or a foreign equivalent degree. Skilled workers means it's a position that requires a minimum of 2 years of experience. And then other workers is just unskilled workers. So there's no requirement for like a degree or minimum years of experience. Um, so for that reason, this EB3 category does have high demand. Um, but these are the various options that you do have, the EB1, EB2, EB3. There are some like the EB5, which are for investors. But as I mentioned, for purposes of this presentation, we'll just focus on the EB1, EB2, and EB3. And now I'll pass it over to Pamela.
Thank you, Sela. So let's just talk a little bit more about this labor certification process that Sela has been discussing already. As already noted by her, and as you've seen, most EB2 and all EB3 cases are going to require this labor certification, which is ultimately provided by the Department of Labor or the DOL. And what they're looking for is that the employment of this individual is not going to adversely affect wages and working conditions of U.S. workers, and that there are no U.S. workers who are able, willing, qualified, and able to fill the offered position. I think it's really important to keep in mind that this labor certification process is not to identify the best U.S. candidate that's available. It's to identify if there is a minimally qualified U.S. worker who is available, able, qualified. It's again, it's not the best person, it's the minimally qualified. So that is something that then therefore keeps the pool, let's say, of candidates potentially a little bit broader. And that is the purpose of this process, to make sure that it is not excluding individuals that it should not be excluding. So PERM, it is an acronym. It stands for Program Electronic Review Management. It is an online process. It hasn't always just been an electronic process. For years it was paper, there was mailing and all those things, but now it is online. It does have, as noted here, the process in general. It is strict. The regulations that have been set forth are very are almost like a recipe. As long as you follow them and they are clearly set out, then it should be something where the ultimate outcome should be success. Again, so long as there hasn't been this minimally qualified U.S. Worker who applies and can take the role. It is a three-step process. It begins with this prevailing wage determination, which is mentioned here on the slide, which is exactly what it sounds like. It's the government letting us know what is the minimum wage that should be paid for this particular role in this particular location. The PERM process has, aside from becoming online, it has been modernized to other degrees as well. Now the prevailing wage determination is incorporated automatically. So I believe the goal was to make this all a faster process. In practice, it has not played out to be necessarily a faster process with respect to the PERM filing, but the hope remains that that's where we will eventually end up. And this is, at the end of the day, it is an application. It's an application that has to be certified by the Department of Labor. So the Department of Labor can deny it, they can issue audits, they can request additional evidence or documentation to be sure that the proper steps were taken by the employer. That alone can impact how long the processing timeframes can take. But currently right now, that final step to submit the PERM application to the Department of Labor and get a response or get a certification is at this point quite a bit over a year, unfortunately. And we'll see how that continues to shake out. And we can move on. So the I-140, again, the I-140 is the actual petition filed by the employer saying, we've done all of whatever preliminary work, let's say it was the PERM process, that's done. Now we're filing the I-140, and it serves as the basis for the employee to eventually be able to apply for a green card, either through consular or adjustment of status, as Sela had mentioned before. The I-140 is processed by USCIS, which is the primary U.S. immigration agency here in the United States. And it does require that the employee show that they are be able to establish that they qualify. So that's where all of those things that Sela mentioned about, say, EB1, certain criteria to show, say, someone's an outstanding researcher, to show someone qualifies as a multinational manager, all of that would be argued within the I-140, and supporting evidence would have to be provided to prove that what the petitioner, the employer, is saying is in fact the reality. Okay, so let's talk about adjustment of status. As Sela had mentioned, there is this policy memo that was issued very recently, just May 22nd. We are going to talk about that in a little bit as well. But setting just a bit of a foundation here, adjustment of status is for individuals who are lawfully present in the United States or have had a lawful admission, let's say, and are able to qualify to complete the green card application journey within the United States, as opposed to having to leave. So there are going to be times when an individual unfortunately just will not qualify for adjustment of status, and that's where maybe consular processing is the way to go. We will touch upon that in the next slide. But generally speaking, if it's an employment-based pathway to qualify for adjustment of status, not only must the employee have entered lawfully, but they must be continuing to maintain that non-immigrant status, which we talked about earlier, and they cannot have any disqualifying wrinkles in their immigration history, including, say, a criminal history, which frankly would be an issue with consular processing as well. But that is adjustment of status. And so that's for employment-based. Now, with respect to adjustment of status can also be, of course, leveraged in the family-based sphere. It has different, usually or sometimes, eligibility requirements. For example, not for every family-based pathway does there have to be maintenance of non-immigrant status continuously. It just depends on which category we're looking at. A very important aspect of either the adjustment of status process or consular processing is the visa bulletin. It's issued every month. We usually get it about 2 weeks before for the upcoming month. So probably in about a week and a half, we'll be seeing the one for July come out. And what it does is let us know who is eligible to go ahead and apply for a green card. Again, whether it be through adjustment of status or consular processing, the visa bulletin lets us know kind of in a big picture way, or in the way it works is that someone has a priority date either established through an I-140 or an I-130, which is the family-based route. And if their priority date falls any day before the date listed in the visa bulletin, then they can apply. That's a very kind of simplistic way of looking at it. That there are some additional factors there, but that is generally speaking what we're looking at when it comes to the visa bulletin and whether or not there is a green light to apply for the green card. We can move to the next slide. Thank you. So again, consular processing. This is conducted abroad. This requires an application being filed online with the National Visa Center. It's a completely different form. It's called the DS-260, whereas for adjustment, we're talking about the I-485, totally different forms. There is an interview that concludes the consular processing journey. It is, of course, it's at the U.S. consulate abroad. There are, as noted here, there are similar requirements for adjustment of status as with adjustment of status. For example, if someone has a criminal history that could be, say, a blocker, that will be a blocker, whether it be adjustment of status or consular processing. The question will become, is there a waiver available? Do they qualify? So it's very much a case-specific, fact-specific analysis that would have to be conducted. Consular processing also has some additional documentary requirements, such as requesting police clearances for generally any jurisdiction an individual has lived in since they were 16. So that is not something that's required for adjustment of status, because fingerprints are taken here, the FBI does their job and conducts the necessary screening, and then it moves on. But it is something where, for some individuals, consular processing will simply need to be conducted as opposed to adjustment of status, and that's why that option is there. And I am going to actually turn it back over to Sela.
Thanks, Pamela. So now we have an idea of the different non-immigrant visa options and the different paths to getting a green card through employer sponsorship. So I figured we spend just a couple of minutes just discussing compliance. And in the interest of time, this will just be a quick overview of compliance requirements that employers should take into consideration. So if you are an employer in the US, first thing, you need to ensure that you're verifying the employee's right to work. This is usually done with a Form I-9 that every employee needs to complete. This is completed both by US citizen employees and also citizens who are not US, also employees who are not US citizens. Some states require employers to go through the E-Verify, which is an internet-based system operated by the government. So this, some states require it, some states do not. But that's just also another way for businesses to just verify employees' right to work in the United States. And then you also want to ensure that you have well-defined employment verification procedures. How are you as an employer verifying that the employee's documentation is appropriate? And then you want to ensure that you are retaining copies of employee work authorization documents, maintain them for the duration of the sponsorship. And sometimes you also have to maintain those documents even beyond the sponsorship. And then also as an employer, sometimes you do have to satisfy departure requirements. For example, if you have an H-1B employee who was laid off, there is a requirement that as the employer, you would have to facilitate a plane ticket for them to return to their home country and to depart the US. So that's not for every visa. So there's just certain visas that have these requirements. So best practices for employers. immigration compliance risks have increased significantly in recent years. You have government agencies who are, you know, placing greater emphasis on conducting audits and site visits. And so employers just want to make sure that they have all their ducks in a row, just to avoid any issues during a site visit, for example. So want to ensure that you avoid Form I-9 errors, for example, because that could lead to penalties. You want to ensure that you conduct internal regular audits just to make sure that you are keeping accurate records and tracking visas of all your employees accurately. And also just staff training. So whether it's staff training of HR or employees who are keeping tabs of these documents, just ensuring that those trainings are taking place to just keep risk low in terms of compliance with immigration regulations. Another way sometimes for employers to go about this is just partnering with legal experts. So partnering with an immigration law firm, for example, just to assist with this process and ensure that everything is looking okay in terms of immigration compliance and to avoid organization penalties. So as the employer, employers who are acting as a sponsor of a visa have to show that they are able to pay the wages. And so they have to show that they're able to pay the wages through financial documents that are submitted as part of the petition. Um, and usually it depends on which visa it is. But usually if you're going through legal counsel, they can assist with telling you which exact financial documents can be submitted to show that you have the ability to pay the wages for this, to sponsor this for a national. And then also, you have to follow the wage requirements for the state that you're in. So, for example, in Massachusetts, there are certain wage requirements. If you're posting an ad, for example, for a role, and you are an employer who has more than a specific number of employees, then you might need to post a wage range in your ads. So these are things that if you're doing the labor certification process and you're in a state that has those wage requirements, then even the ads that you're posting for the perm process would need to follow those state requirements. So there is some complexity sometimes when it comes to these um, things with the compliance. So employers just need to make sure that they are, consulting with their immigration partners or employment. Sometimes it's also an employment attorney who can assist with these things. And then also coordination between HR, legal, and management with ongoing communication to employees, making sure everyone is on the same page. Job duties that are being submitted to the government, you speaking with the manager, ensuring these are the accurate job duties for this role. And then also just ensuring that the sponsorship programs align business goals with regulatory adherence and employee retention strategies. So you want to ensure that you're retaining employees, whether it means that sponsoring them is a one way to be able to keep this good employee who's doing great work. So retaining employees, following the regulations, and also just aligning with the business goals, which at the end of the day, businesses want to make a profit. So if this valuable employee who needs sponsorship will allow them to reach that goal, then maybe there's certain things that they want to consider in terms of sponsoring them. As an employee, what do you need to do? Just make sure you respect your obligations and restrictions. So attached to your work authorization. For example, if you're an H-1B employee, your work is tied to a specific employer and you cannot work for a different employer unless that other employer takes over as the sponsor of your visa. And then you also want to make sure that you notify designated agencies of any changes. So, for example, as Pamela had mentioned, if your address changes, you have to notify the US government of any address changes. And then you also just want to maintain your immigration status. Apply for renewals as required. Keep tabs of when your visa is expiring and initiate the process of extending that visa well in advance, just in case of any delays with the processing time. Over to Pamela, just to touch base on some of the updates and trends with the current administration.
Thank you, Sela. So to say that this current administration has been active in the immigration sphere is, I think, an understatement. There's been a lot going on. It will likely continue to be very active. And there are a few that we do want to kind of specifically point out, listed on the next slide. Something that we think is important to highlight is that the law itself has not changed. The law, in terms of what's encapsulated by the INA and things like that, that has not changed. But what has changed is how the government is approaching immigration in general, and where it can have, say, discretion and things like that that are not encapsulated by, say, a rigid legal framework. That is where this administration has been emphasizing or prioritizing its actions. So this first item, following an I-45, which is the adjustment of status application, if that is denied, USCIS is now more automatically issuing a notice to appear, unless, of course, an individual has underlying non-immigrant status, for example, still has H-1B status. Then that's when the agency shouldn't, and we have not been seeing them issue these NTAs. But this NTA, or notice to appear, it is a very significant document. It's the document initiating removal, or what is more commonly known as deportation proceedings. So, of course, avoiding that being issued is paramount. And historically, there hasn't been this automatic issuance of NTAs when an I-45 is denied, but that is at this point something that is more under what USCIS is doing. Their actions are in that direction. In a similar vein, with respect to interviews, if anyone, I'm sure at least some individuals on this call, you've seen the news. There have been these stories, frankly, can be somewhat alarming, or rather alarming, about enforcement action at interviews. So agents showing up and detaining individuals at the conclusion or at some point during an interview with a USCIS officer. This had historically been rather rare. It is happening more frequently now. An important note to keep in mind on this front is that in terms of the information that is available regarding this type of action, what we've known or what we've seen is that it tends to be in scenarios where there is a complicating factor. For example, an individual who's showing up for an interview due to the petition filed by their U.S. citizen spouse, and it turns out this foreign national has a longstanding removal or deportation order from decades ago, maybe when they were children and entered as children, and that increases the likelihood of some type of enforcement action at the interview, which wasn't really present before. There's been this adjudication pause for individuals subject to the travel bans, which Sel is going to talk about international travel and the bans associated therein very soon. And actually, we have literally breaking news right now that apparently there's been a federal court that is not upholding this adjudication pause. So for now, there may be some measure of temporary reprieve on that front. It remains to be seen how that is, of course, all going to shake out. The administration may likely appeal, so we'll see how it actually shakes out. But for now, there does appear to be some legal action that is not upholding or not in alignment or agreeing with this adjudication pause issued by the administration. Again, we'll see how that ends up playing out. The issuance of immigrant visas, which is the green card issued through the consular processing journey or pathway, that has been suspended, unfortunately, for many countries, not known when that's going to end. Administrative processing is being leveraged more extensively for visa stamping, which essentially puts a case in limbo for an undefined amount of time. Other items here, as we know, the Supreme Court is weighing whether or not to agree with the administration about birthright citizenship, CSPAs for individuals who are children and want to apply through their parent as a derivative applicant for a green card. Sometimes they're protected from aging out, or when they turn 21 from they get to still be eligible for the green card. That has been narrowed in scope under this administration. It could be that in the future, F1 and J1 are no longer going to have that duration of status designation. There will be a fixed designation like there is for the other categories. H-1B, for example, they have a fixed date on which status ends. F-1 and J-1 have historically had this D/S or duration of status that is also now being reevaluated by the administration, and consular operations have been impacted. Consulates are have a lot of cases, a very substantial backlog that continues to be increasing. There's apparently going to be a drastic reduction of the US consulates in Africa in terms of the number of them. So that will, of course, lead to just general more strain on the consulates that do remain open. And then finally, the adjustment of status policy memo, again, issued on May 22nd, just to touch upon that a little bit more. Again, the law itself has not changed. An individual who's eligible to apply for adjustment of status, they are still eligible. What this memo does is really bring to the forefront USCIS's discretionary aspect of adjustment of status, whether or not an applicant is eligible for a favorable exercise of discretion, thus resulting in the green card. This discretionary component has always been present. It is not new. It's just something where this policy memo is emphasizing it in a greater fashion. And so something where it remains to be seen how much impact it will have in practice, but certainly something to keep in mind for anyone who's considering adjustment of status, essentially looking at what are the positive factors, what are the negative factors, if any, and how to argue those if needed before a USCIS officer. And then finally, current administration considerations. What should your family be aware of? What should you be aware of as a foreign national navigating the immigration sphere? So consular processing has become more challenging, as I mentioned just a couple of minutes ago, with administrative processing, but also in other ways. Interview waivers are now not really available unless there's a very specific exception. So thus adding to the consulate's backlogs, just adding to all the processing times. Third country national processing had previously been a very helpful tool, allowing individuals to say go to another country, a more nearby one, if needed. That is largely unavailable at this time. And then with respect to USCIS, which is again the agency here in the US processing petitions and applications, there are more background checks. Things are taking longer on that front. And very similar to what I mentioned before about if an I-45 is denied, USCIS is more often issuing this notice to appear. The same thing applies on the non-immigrant front. So if, say, a family member's I-539, their application to extend, say, H-4 status is denied. And the H-4 status that was previously in place has already expired due to the processing timeframe. Then USCIS will be issuing a notice to appear for that family member. So certainly something where there is, a fair amount of activity going on to be aware of as you plan. And over to Sella. You're on mute, Sella.
Did that again. Sorry. I know that we're a little bit over time here. Maddie, is it okay if we're going a few
Ah,
minutes over time?
yeah, that's okay. This is important, so I want you to be able to go over all your content.
Okay, thank you. So just travel. We figured we're going into the summer months. Everyone has travel plans. So just if you're someone who is a non-immigrant or a green card holder, just things to be aware of as you're traveling. One thing, a big one, is the travel ban. Are you or your dependents subject to the travel ban that's currently in effect? You want to make sure that you take that into account. And the next slide will have just a list of the countries that are subject to that travel ban. Another thing to be aware of is the travel documents. Your passport. Is your passport valid? It might be a while since you used it. Just take a look, make sure it's still valid for you to re-enter the US after your travels. And for you and your dependents. Another thing is the visa stamp that's stamped into your passport. You want to ensure that that is still valid so that you can use that to re-enter the US after your travels. Same thing for your dependents, not only for you, but for your dependents as well. A big one right now, just based on the current administration, is have you or your family member, have you had a prior or recent encounter with enforcement, even for a minor violation? If there's any criminal issue at play, we just recommend that you seek counsel prior to leaving the US, just to avoid any potential issues when you're trying to return to the US after your travels. So the travel ban, this slide basically has a list of some of the countries that are, if not all the countries that are impacted by the current travel ban. So effective January 1st, 2026, these countries have a suspension of both immigrant and non-immigrant visas. And then for some of these countries, it's only non-immigrant visas that are suspended. I'm hoping that, there is some litigation and hopefully this doesn't play out for too long. But currently, individuals who are outside of the US as of January 1st and did not have a valid visa, those folks who are currently outside the US, if they're from these countries, they are not going to have their immigrant visa processed at the US consulate abroad right now. Or for some of these countries, they will not have their non-immigrant visa processed at the consulate abroad while this travel ban is in effect. Another thing that's as of just like May 18th, I think, Ebola crisis. There are some countries in Africa currently facing the Ebola crisis. And so the CDC placed an order saying that if you are a non-US citizen who traveled to those countries within the last 21 days, then you are temporarily prohibited from returning to the US. So those countries are Democratic Republic of Congo, South Sudan, or Uganda. So those three countries have a temporary ban for people who traveled there within the last 21 days. Another thing is the visa bond. Unfortunately, some foreign nationals applying for a visitor's visa or a business visa from a specific list of 50 countries, so long list of countries, currently have to pay a bond to be able to use that visitor's visa to enter the United States. So the bond is either $5,000, $10,000. It's a high amount. So basically, the point is that the US is saying that some of these countries have significant overstays. So they're trying to get these people to pay the bond so that once they return to their home country, then that money will be given back to them. So unfortunately, some nations do have this visa bond. Some are facing exceptions for the World Cup that's coming up. Is it next week? Sometime this month. So if you are traveling here for the World Cup and you're an athlete or a team member or a relative, then you might qualify for an exception to this visa bond, but everyone else is subject to the bond that they have to pay to enter here as a visitor. So these are the changes. I know we're over time and I'm probably speaking very quickly and I do apologize, but I just want to respect everyone's time. So those are some of the changes that have been taking place recently. Um, Hopefully, you will leave this session with some kind of background information of the non-immigrant visa options available to you, the immigrant visa options available to you, things as an employer to take into consideration to ensure compliance with immigration regulations, and also you, if you are a foreign national, the things that you should keep in mind when you're trying to comply with immigration regulations or traveling in this season, this summer season. So with that, I just want to thank everyone for joining us today. I know we're over time, so I'm not sure if we have time for questions.
Yes, Sarah and Pamela, would you guys be open to staying on for a few more minutes to answer any questions that come up, or do you guys have to go?
I think we can stay for a few minutes, sure.
Okay, so if people have time and they want to stay on for a couple more minutes, if they have any urgent questions, if you guys do have to go, I'm actually going to end the recording here, but everyone will